So we are a country that does not have the right to privacy in our constitution.
But the more protection you afford in a jurisdiction in terms of data protection, that would be considered, in my opinion, as a data protection haven, so to speak.
Now, one of the things which they are highlighting is most countries have a data protection law, but enforcement is weak, which means most of the discussions have been centered around the G20 countries.
Hello and welcome. You're joining a discussion on the Personal Data Protection Act and its intersection with laws, businesses, and society. And in the studio with us today are Sanduni Wickramasinghe. Sanduni is a legal consultant on information privacy and technology law. Also here is Sujit Christy. Sujit is a consultant and Chief Information Security Officer and Cybersecurity Advisor to several listed and private Sri Lankan companies. And also here is Dr. Gehan Gunatilleke. Gehan is a partner at the legal firm LexAG. Welcome. Let me start with you, Sanduni. Once an authority is in place, if as the budget suggests an authority is in place, what does that mean? Does that mean the act is fully enforced and in law?
So if you look at the act in terms of the implementation, so there's a grace period recognized there. So it's a staggered implementation, so to speak. So initially you have, when the act was certified by the Speaker in March this year, some of the provisions came into operation.
Right.
So, so the next step would be for the authority to be set up, because there are certain quite a variety of rules, regulations, and guidelines to be issued by the authority. So, which would give a lot of clarity to some of the provisions in the Act itself. So, once the authority is set up, we are looking at a grace period of 18 to 36 months from the date of the certification of this Act for the rest of the provisions to come into place. So when I say rest of the provisions, we are looking at things like the principles of processing under Part 1, the rights of data subjects, other obligations of controllers and processors, and so on.
Okay, so let's try to simplify this a little bit, right, to all three of you, right? And I'll start with you, then perhaps Sujit, right? So the Act grants certain rights and privileges to individuals whose personal data may be stored in systems in private companies, in government, etc. It also enforces certain obligations on those who hold personally identifiable data. Now, the question is, once a so-called regulator or an authority is established, do all those rights immediately become active? You know, if you try to demystify that a little bit for us.
So I think stemming from what Sanduni mentioned, we need to take a staged approach. Right? So when I say a staged approach, first we need to understand what is the governance structure we need to have in place. This has no bearing in any of the rules or regulations which are going to be set up by the authority. So you need somebody in the organization to own the data and administer it.
This is the controller that Sanduni was referring to.
Right. The second thing what we also need to look at is the data is in our custody. How do we collect? How do we store? And how do we use it? Right. This, I think, we need to look at it from creating trust with the data subjects. So unless we create that trust in the way we collect data and how we store it and how we use it, nobody is going to be using it, right? So if people don't adopt digital technologies, then there's no purpose of collecting the data or even having an application or a technology for that matter for you to use it, right? So my take is start looking at these simple steps in-house while we await the regulator to be set up, the authority to be set up, and then they will define the various rules that mostly it will be in terms, in my view, is in terms of what would be the reporting guidelines. If there is an incident, how would you report? How would you do an impact assessment? So those things will get detailed out in days to come.
Right. Sanduni, you were part of the committee that drafted the law, right? So, like, following on from what Sujit is suggesting is that the regulator then has to come up with detailed operational instructions almost. Is that a fair way of putting it?
Yeah, in a way, I suppose, because you would see when you look at, for example, exercising rights of data subjects. So the Act gives out, recognize certain rights, but it doesn't spell out the procedure to exercise those rights. So you need to have the authority to coming up and saying, this is the procedure you need to follow as a data subject, as well as the control. The kind of, fees could be involved in exercising these rights, and all this will be specified or clarified by the authority by way of rules, regulations, or guidelines for that matter.
So, I think a lot of the inspiration for the Act may have come from also what Europe has done with GDPR, which was, I think, enacted into law in 2018. So we are not very far behind as a country. Now, Europe is a big market. There is potential, I suppose, among companies and also maybe even individuals to sort of deal with the intricacies and implications of such a big law, right? Sri Lanka's law is very similar, if I understand it right, Gehan. Now there is an open question about, okay, is this burdensome, or is this something that Sri Lanka can deal with? I mean, let's discuss it. And if you start with that, what are your views on that?
So that's a really important question, and I suppose the first thing to ask is, what is the Act trying to achieve in terms of a culture shift, right?
Right.
So we are a country that does not have the right to privacy in our constitution. The idea of data protection is also fairly new. So this Act is actually introducing a concept, a value that is, I wouldn't say foreign, but certainly not something that is familiar within our legal system. So it's a big step, but I think it's an important step in the right direction. And if you take a step back and look at the Act as a piece of legislation, there's a common value that threads through the Act, and that is the idea of informed consent. It's the idea that we as data subjects, as human beings, we own our personal data. It's precious to us, it's important to us. And if we are going to have some entity, whether it's government entity or a private entity, process our data about ourselves, then we must be fully aware of how that data is going to be used. So informed consent is a very, very important value and principle that threads or runs through the law. I think that's a very important step in the right direction. So yes, it's ambitious. Yes, it's following in the footsteps of a law that was only a few years ago introduced in a far more sophisticated market like the EU. But at the same time, we have to be prepared for the future, and digitization and e-commerce is the future, right? So this lays the foundation for an economy that is better equipped to deal with that. So I think as much as this is somewhat new territory and an area of law and a legal vocabulary that is somewhat alien to us, it's a step in the right direction, and over time we will absorb those values and we'll be able to implement it better. So it's very early on in the process. I'm optimistic because I think we have to start somewhere, and it's better to have a law that meets international standards, meets global sort of benchmarks, than a law that doesn't, and where 2-3 years down the line it's not fit for purpose.
Sure.
So in a way, I think it's a good start.
Sure. Sanduni, I'm sure the framers of the law had to consider this fundamentally, right? Because even in the region, there is no data privacy law that goes as far as the one that Sri Lanka has proposed. Not even in Singapore or Malaysia, I think the data privacy laws go as far. Particularly in Malaysia, it's not government managed data is not covered by their data privacy laws. I'm sure this was front and center in the discussions you were having. What was the rationale, if you can generalize, then what your thinking was when you framed this law?
Okay. So I mean, I can only speak for myself
Sure,
here.
of course, yeah.
So I think the idea was, at the time when we started the drafting process, India already had a bill at that time.
Uh-huh.
So in 2019, the Indian bill was out, which was later withdrawn by the Indian Congress sometime this year, I think. So when we looked at the Indian approach, what we realized, it was fairly more conservative in terms of protection towards the data subjects, as well as they had, of course, excluded most of government processing. And the idea when the drafting began in early 2019 with the Sri Lankan Act was that we need to treat both controllers, whether it's public or private, in an equal footing. So because you're looking at government entities having a host of data in Sri Lanka, and they're moving towards all these digitization strategies and adopting various digital tools, and without having that sort of safety net to protect the use of utilization of personal data. So it's not just a problem that was envisaged within the private sector, but also within the government sector. So we realized it was the only opportunity we would ever have to broaden the scope of this act to include both public and private sector.
Sure.
And I think it was a blessing that the administration at the time and even afterwards sort of supported this notion, and the drafting went ahead with that basic idea in mind.
Sujit, if I can bring you in, I suppose there is a reasonable level of digitization within private sector organizations, at least among the big ones, where they may be able to sort of get their head around what private data they hold, personally identifiable private data they hold, and how to deal with that, right? But I suppose the challenge is going to be monstrous with the government, which holds enormous amounts of personally identifiable data, right? When you look at the enormity of the challenge, how does Sri Lanka start approaching this?
Good question, and I go back to Gehan's statement, a very positive, forward-looking act. Right? So that's very encouraging, because we are not saying this is the begin and end of all, right? So we are taking a gradual approach. So with anything we try to do with technology, we have to start with awareness. So here we are looking at creating that awareness and changing that cultural mindset of moving away from paper to digital adoption. And in terms of even collecting the required data or how it is going to be shared. Now today, we all know if you go to the neighbors, now I take public transport a lot. And the best way to find a lot of information, including what happens in the parliament, is you talk to the cabbies, right? They'll tell you what conversations actually happened and what disagreements people had, right? So there's a lot of cultural change which has to happen within, and that will only happen if we create that awareness. And it's no easy task. You've got to continuously tell people that this is what they need to be mindful of. And be conscious of any PII. I'm not limiting it to PII. We are also talking about sensitive information.
PII is personally identifiable information,
and personal sensitive information. That could be sexual orientation, or it could be any health-related information. We are talking about health information. So it becomes more complex. So you visit a clinic, you walk up to the reception, yes, okay, what did that person come here for? And if that person is going to divulge that information, then there could be a breach. What we are looking at is not necessarily limiting this conversation to technology, but beyond technology.
Gehan, you referred to this act as ambitious also, but suggested this is absolutely the right way forward for Sri Lanka to move. And when you look at the practical challenges that we are likely to confront, you are a legal professor, you are in the legal profession, you work with Sri Lanka's legal system and its peculiar challenges. I suppose you might be fairly aware of that. What do you think are likely to be our big headline challenges?
Yeah, absolutely. I think for me, just thinking about the experience in related areas like right to information, right? Areas that are analogous in some way because we've introduced it recently. I think the biggest challenge is going to be institutional culture. Right. I really think that when it came to right to information, I'm using that as just an example, we had a culture of being closed. And then suddenly we're expecting institutions to be open, right? So that's a big shift. Similarly, we have a culture of not treating personal data as important and precious, because over time, that hasn't been part of our institutional culture. Suddenly, you're asking institutions to make that cultural shift. I think that'll be the challenge. So you might have a law that, on the face of it, has a very good text, right? All the necessary provisions are there, but the proof of the pudding is in the eating, ultimately. And ultimately, it'll be down to enforcement and implementation. And institutions may find themselves struggling to make that shift. So that's why I think I completely agree with the idea that there needs to be a lot of awareness raising, a lot of sensitization, a lot of training around how this act really translates into reality on the ground when it comes to institutional culture. That's going to be, for me, the big challenge. I mean, I can see areas in which we would need the courts to step in and interpret specific provisions in the act, because always you can have a very good provision on text, but then it requires a judicial mind to sort of, iron out the ambiguities. And I think there are areas like that. For example, there are exemptions and derogations and limitations on the grounds of public order, national security. These are big concepts. And you need the courts to step in and say, these are the limits. This is how we interpret these exemptions. There's time for that. And there'll be litigation at some point where courts will get that opportunity. But apart from that, I think institutional culture shift is going to be the big challenge.
In your sort of example, the example that you used RTI, the right to information. Is RTI incorporated is part of Sri Lanka's constitution? Is it by any chance?
Yes, it is.
And you mentioned earlier on that the right to privacy is not a concept recognized by the constitution. So I suppose the challenge is that much greater with...
Absolutely. So that's a really great question. And when before the RTI Act was enacted, we had the 19th Amendment, which brought in Article 14A of the Constitution, which explicitly recognizes the right to access information, right? So that right to information became constitutionalized. Now, we don't have a similar provision in the Constitution through a constitutional amendment recognizing the right to privacy or data protection. So there is that gap. But I don't think that's a big challenge. I mean, the statute encapsulates rights, and we have statutory rights. And we would still have the right to information even without a constitutional recognition of that right, because there's a statute that recognizes that right. So I don't see that as a huge challenge, but I do think that institutions will take time to absorb the idea that this is very important, and it'll come down from the example that's set right at the top, right? So the more you hear leaders talking about this and promoting these ideas, the more institutions will absorb those values and principles, and over time implement them. So there's a lot of work to be done, and this is just the starting point, I think.
So when he says a lot of work to be done, what I like with the Act is it gives us room for us to build those rules, right? And also, as part of building that rules, I think we need to inculcate the accountability aspects, right? And I think that is lacking in every aspect of life, right? So everybody talks about responsibility, but who is going to be accountable? So I think when we bring the Right to Information Act, data privacy, and constitutional rights, what we are looking at, in essence, is to build a good governance framework. How do we govern the data? Right? Certain information can be in the public domain, and what information should be sanitized and protected. And I think that's where we as professionals and the industry together will have to work in building those rules as to how we are going to take this forward to the world.
So as far as rolling this out in government in particular, Sanduni, the challenge is not just awareness, but it's about building those governance frameworks. And technology is challenging even for young people, right, to also understand the implications and the operation of it. This is not going to be easy. when in government, where I suppose senior officers, public servants are fairly senior?
It certainly will be a huge challenge. I think, this was in the back of our minds when the drafting took place, because, sometimes private organizations may have that capacity financially or technically or personal-wise. But the government, we cannot expect the same level of commitment from government entities. But the idea is that you need to start understanding this little by little, because one of the concepts when we speak about privacy management, data protection management within an organization, is top management buy-in. So it's it's where the top management is convinced about the importance of being conscious about data protection, and take it not just purely from a compliance perspective, but also building credibility and consumer trust and so on. So they understand the benefits of the compliance. So it's not just to avoid legal penalties or or paying compensation to aggrieved data subjects. So that sort of top management buy-in should translate into the government sector as well, where the heads of departments and ministries understand the value of it and the gravity of this law and the kind of benefits that they could accrue from it. And these benefits are not just limited to the private sector.
Sure.
And just to add to Sanduni's thing, I think the Act is very clear in terms of the penalties, right? And I think that's what people need to understand. That's where the accountability comes in. Now, we had another conversation in another forum. When we spoke about the accountability, it was pin drop silence. And we said, the Act talks about your accountability and that you're going to be answerable and you're going to be personally held liable for any mismanagement. And that's a shocker for everybody because people are not used to that. And that has also got to change, right? And that's a huge cultural change.
You refer to data subjects. Can you, several times we've had that, can you just quickly define that for us, Sujit? This is individuals you're speaking to, or can that include organizations?
It includes both individuals and organizations whose data can be taken as
so let's switch from the government to the private sector that again holds a lot of personally identifiable data. You can identify individuals, organizations specifically by sort of examining that data. We've seen how in Europe, for instance, GDPR of recent times, at least I've noticed in recent times, has been used very powerfully to sort of bring enforcement against even the big platforms like Google, for instance, in some countries, for their lack of adherence to the provisions of GDPR in Europe, right? I'm sure this is not the sort of sole focus of the law, but if somebody, if we are sort of looking at the possible implications of having such a law, okay, let's see, what should private sector companies then be mindful of, if GDPR can go that far in Europe?
So today we are talking about a global economy, right? And we are talking also about digital economy. We are talking about cross-border. So traditionally we had borders and we operated within within those borders, and we had our own set of rules. Now when we go across borders, and sometimes people think, are we being competitive? Or can we use data and exploit it to gain an undue advantage over? So now I see very positively acts like Data Privacy Act, very positively, because that gives us a level playing ground. Because it says, okay, if you want to operate in these markets, this is how we expect you to handle the data. For some companies right now, when they have to enter a new market, it might be a bit of a challenge because they have not thought through the process when they did the product development. Privacy by design, security by design. And I'm taking Sanduni's word. She used to frequently use those terms. So when those concepts are not built into product conceptualization, you are now entering a market and you find that you are not on par with what is expected from all the players. And then that gives room for litigations and various other things. And I would always say, if you can shift left, and when I say shift left is look at all these requirements at the beginning rather than trying to address this downstream. If you do it at the beginning, of course, there will be slight delays in getting to the market, but you'll get it right. But if you try to fix it at a later point in time, the costs are going to be so huge, and sometimes it might even determine the fate of your future.
Sure. Another aspect of this, and it's open to anybody, right, is that Sri Lankan companies have been sort of suggesting that they're at a disadvantage because the playing field is not level. You are incorporated here, you're taxed here, you're subject to Sri Lankan laws, whereas we have this notion that platform companies based overseas don't have any of those obligations here. Is this in some way a step towards correcting that? Does that need correcting? Is this, in your views, a step towards that?
Sanduni, you take first.
Well, I wouldn't say it's disadvantageous for local companies, because one of the things about data protection regimes globally is that it's important to have one in any country if you are to attract investment in this area. It's a little different from having tax laws, because the lesser tax you have, you call it a tax haven. But the more protection you afford in a jurisdiction in terms of data protection, that would be considered, in my opinion, as a data protection haven, so to speak. So when you're competing with, just leaving out the big social media players and internet companies aside, when you're pitching your products, especially for the European market or to countries which has very comprehensive data protection laws, it comes as part of the deal that your product conforms to those compliance requirements in those countries. And one of the things, especially in the European Union, insists upon is that whenever they do cross-border data trades or cross-border data processing, is the recipient who receives the data of the European citizen data or European resident data should be in a jurisdiction which provides a sound level of protection.
Right.
Or the recipient itself should be able to ensure that the high level of data protection is provided to the EU data subjects' personal data. So in that sense, I think it's important when you're designing your projects or when you're pitching your projects to foreign markets, having a law in Sri Lanka, which actually enhances your image, your credibility in terms of being able to achieve these laws, because you're already in compliant with the PDPA in Sri Lanka, where you can draw a lot of comparisons or parallels to GDPR itself. So I think it's a positive take, especially for IT service sector in Sri Lanka.
Any thoughts?
Yeah, I think in one of the World Bank and World Economic Forum articles, they're talking about the privacy laws and how it can actually help enhance companies' social economic positions. Now, one of the things which they're highlighting is most countries have a data protection law, but enforcement is weak, which means most of the discussions have been centered around the G20 countries, and probably the middle and the low-income countries have been excluded from those conversations. And for us, looking at it from that perspective, it gives us to get in there and have that dialogue, especially to have that cross-border dialogue. And this is in the right direction, where it will also help streamline the global tax structures. And I think that's a conversation which is happening. If you speak to the financial experts, I think they would give you more insights on that. I'm no expert in that. But the little knowledge I have is there are discussions which are in progress. And with that coming in, they're going to look at the amount of turnover, the profitability, and how that money is going to be distributed amongst the countries in which they actually operate.
And there's an initiative for a minimum corporate tax, led by the US. I think is 15% is being floated as the
exactly,
as
and the
number.
UN is also now jumping into that.
Right. Okay. So is it? We see tech giants sometimes as predatory. If Sri Lankan individuals or corporations wanted a more level playing field against tech giant, global tech giant that's seen as predatory at least on PII. I suppose this law can then also be the foundation for trying to level the playing field.
I mean, just to add a thought here, one of the questions that we obviously have is what incentivizes the implementation of this act? right? Because this is as I said before, it's ambitious. And how do we get companies, how do we get entities that are subject to the act to actually take it seriously? And I think Sanduni was quite right in pointing to the global connectivity angle, that the moment our laws become aligned with benchmarks that are globally recognized, we become an attractive place for investment. We become an attractive place to where services can be provided. That's I think an important point. To add to that, I think consumers are also changing and evolving in terms of their priorities. And data protection is a huge priority for consumers, particularly on social media platforms, consumers of technology generally, particularly young consumers. They're very conscious about their data and they're conscious about their rights in a way that perhaps previous generations were not. And I think there is a business case to be made in terms of actually really embracing this approach, because at the end of the day, consumers are going to be looking for companies that are more compliant with data protection when they choose which companies to work with, which companies to obtain services from. So there's a huge long-term incentive here, and I think that's worth thinking about, as a country and as a sort of industry, but also as companies that are thinking about their market.
The fact that some countries want to bring legislation that compel platform companies, the big tech platforms, to host their user data relating to that country in show was, I think, a debate, I think even in India, right? I'm not sure whether that came in the context of personal data protection. Has that been is that a thing that the Act aspired to do? Can it be done with regulation, or is that something we shouldn't really be too concerned about? What are your views about it? Where the data is held?
Okay, so let me answer how the location of data is addressed in the Act and where it comes up. So it comes up in provisions relating to cross-border data processing, and there is a sort of a limited localization requirement. So localization is the data has to be processed as in stored, processed in any other way. Should be, must be within Sri Lanka. So there is a conditional requirement for public authorities to localize their data in Sri Lanka. So by public authority, it means ministries, government ministries, departments, and so on. So the idea stems actually from a data sovereignty point of view. So having government, because when you're for example, think about DRP, the Department of Registration of Persons, or the Immigrations Department, having host of data about Sri Lankan citizens. And imagine that data being hosted in a cloud or like a server outside of Sri Lanka. So, it could be a friendly nation now, it may not be a friendly nation later. So there is a sense of risk involved when you sort of think about hosting data outside of Sri Lanka. So this conditional provision was introduced to maintain data sovereignty over data when it's processed by government ministries and departments.
When you say conditional provision, just to jargon bust that a bit, that means that doesn't mean.
No, it doesn't mean. So the Data Protection Authority, once it is established, has the mandate to consult the relevant ministry or the department or any other corresponding regulatory body and decide and classify data and decide which data can be stored outside or processed outside of Sri Lanka.
The Act itself hasn't mandated this. It is incumbent on the regulator to decide how to treat this, right?
I have a view on this.
Sure.
Right? So, yes, agree with what Sanduni just said. We need to be conscious of where the data, what's the data and where it's going to be hosted. But just having the data by itself, we can't do anything. We need applications. And we are totally dependent on other countries. If you take the big brands, right? We're using all of them. Let's look at what happened to Huawei. Right? The US said, let's not allow Google to give their technology to Huawei. So all the devices were brought to a complete unusable state, right? It can happen with anyone. So as she rightly said, okay, a nation today, a friendly nation, can become a hostile nation. We are seeing that right now in the geopolitics. Right? So I don't know whether we have an answer for that, right? Not that I just want to contradict that, but I'm just saying we need to be conscious of it, but we can't be extremely paranoid about it and not do anything about it, right? We need to continue doing business. If we don't do it, we'll be left behind.
Again, can I bring you in about how might PDPR be abused in the hands of the government? Before this conversation, you were talking about the dichotomy of the Prevention of Terrorism Act and the ICCPR regulations, how they are both being abused in the Sri Lankan context. So if you sort of apply your constitutional law approach to this, what should we be mindful of?
Sure. So just to explain that point about the Prevention of Terrorism Act and the ICCPR Act, the PTA is considered to be one of the worst pieces of legislation ever drafted.
Sure.
The ICCPR Act is considered to be one of the better ones. They're both abused, right? So the point there is, you can have a near perfect text, but if there's bad faith, you can always abuse a law.
Sure.
Right? So the PTA is bad in terms of its text itself and lends itself towards abuse. As the ICCPR Act is meant to bring in an international treaty that is a sort of gold standard on human rights into our domestic law, and it does that to a great extent, but yet it is abused to target dissenters, target media personnel, target short story writers that are really not inciting violence. All those problems come under the model law, which goes to show that we shouldn't assume that just because the text of the law is really good, that it's beyond abuse. Now, what are some of the risks? One of the risks I do sort of spot in the Act is with respect to national security and public order. We're a country that has gone through a long civil war. We've had several atrocities even after that. We've had violence in places like Gunatilleke. We've had the Easter Sunday attacks. We generally have anxiety and a sort of preoccupation when it comes to national security. But that shouldn't be a blanket cover for decision making. And when we say the words national security, we often find institutions sort of retracting and deferring to whatever authority is claiming that. And we have had rather remarkable sort of interpretations of what national security entails. Now, in the right to information determination in the Supreme Court, it was found that even a discussion over an investment agreement can be treated as a matter of national security, which I find bizarre. Right? So the concept of national security has become very fluid and all-encompassing. My concern is that if we don't have good jurisprudence that defines this concept clearly and precisely, we might have too many exemptions to this law on the grounds of national security and public order. And that's a risk that we need to watch out for. So for example, just to take a concrete example, under the Act, the data subject has the right to get data rectified. So if there is some information about an individual out there that is incorrect, that is false, there is a right to get the data controller to correct it. Now that's a fairly straightforward right. Now, the Act provides for an exemption or an exception to that on the grounds of national security. Now, can we really rationally, sensibly say that my right to get something corrected, something that is false, corrected, should be subject to national security? I mean, maybe there are some very, very extreme circumstances out there that might fit that situation. But certainly that shouldn't be a blanket grounds on which we're deprived of that right. So I think that, again, there needs to be a process through which this Act matures, because it's a young Act. And in that maturing process, we'll learn that there are certain things that need to be interpreted a little better, with more precision, and then courts have a really important role to play there. So those are the sort of risks I identify.
I'll quickly ask each of you to present some final thoughts, but before we get to final thoughts, one last question to you, Gehan, and that is, researching this panel, I discovered that GDPR is being abused, if you will, for instance, in the UK, to muzzle media. Oligarchs, Russian oligarchs, tend to prefer GDPR to sort of muzzle media versus using libel laws, right? Can you set some context for us about how potentially that can happen, and again, talk a little broadly about how we are presented here?
So yeah, defamation laws are always a sort of a tool in the toolkit of a powerful actor to suddenly push an individual who is asking the right questions to step back, right? And you have that quite often. Like you will have a journalist, investigative journalist, building a piece against someone who's very powerful. You might have a letter of demand saying that you are defaming me. So that's already in the arsenal of a powerful actor. And yes, this law could also be used in that fashion, but that's where the Data Protection Authority will play a crucial role.
Right.
It will set the standards, it will set the culture, it will set the guidelines on how this act will be implemented. And once this authority is established, and this has to be done quickly, once it's done, once resources are allocated to the authority, that authority will begin to set the sort of tone on how the act could be implemented. And if powerful actors find that you can't use the act in that fashion, then they will still have other options. But I don't think we should assume that risk is not a real risk. You're absolutely right to point to that. Yeah.
Right. So I'll ask each of you to give us any final thoughts you may have. Can I start with you, Sanduni?
So I think we spoke a lot about rules and guidelines and regulations coming up through the Data Protection Authority. I think one final remark I'd like to emphasize is that the rulemaking power of the authority is subject to public review. I think that's one of the very positive things that I personally find in the Act itself. So there's an opportunity for the public to review over these overarching rules, especially in the context of explaining the exemptions and derogations and things like that, as well as enforcement of rights and application of principles. So I think all in all, you need to start your compliance process early, so that it will help organizations, private and public alike, to make sure they fall in line with the provisions of the Act sooner than later.
Right. Sujit.
I echo Sanduni's thoughts. In addition to that, I think this authority which we are referring to has to be neutral. That's very, very important for us to make this act a level playing ground.
I mean, I just want to end by saying that this is a very exciting, piece of legislation, and it's taking us into the 21st century, so to speak. And I think that, just to echo the thoughts of my colleagues also, ultimately, if we have an independent body acting in good faith to implement this act, I think there's a lot of good that can come out of it. At the same time, the risk is if you have bad faith actors trying to utilize this act for purposes that are not within the spirit of the act, it could also produce a lot of risks. So it's all in the implementation.
That's where the systems become weak.
Yeah.
Right. So Gehan, Sanduni, Sujit, that was a riveting conversation. Really appreciate you taking the time out.
Yeah. Thank you.
Thanks for having us.
Thank you.
Thank you.